The state legislature also appears ready to remove the special legal protection that Colorado's law enforcement officers receive. You heard a sheriff say right here that without what's called qualified immunity, his officers would not risk intervening in tough situations. Well, the state Senate passed a bill today to kill qualified immunity, that protection from legal liability, personal liability for officers. And it looks like the House will do the same. Here's Steve Steger.
They didn't want government officials, including police officers, to hesitate in making split-second decisions.
That is the purpose behind qualified immunity. It's not necessarily a law, but a standard upheld in courts. Basically, if you go to the courts to sue a police officer for violating your rights, say by using excessive force, you have to prove two things.
Not only that the officer did use excessive force in a way that violated your rights and was illegal, even if you prove that the conduct was in fact illegal, you still lose unless you can point to an earlier case with basically exactly the same facts.
That's Ian Farrell, by the way, a constitutional law professor at DU.
The court has said, okay, fine, that's excessive force, but we don't see any earlier cases where the police did exactly the same thing, therefore you lose.
And Farrell says oftentimes in cases like this, a court doesn't even rule on conduct, which can make it awfully hard to create precedent.
There may never be this clearly established rule because the court never gets to that particular question.
The accountability bill making its way through the state legislature right now removes that requirement. You don't have to point to the result of another identical court case. It would only apply in state court, but Farrell says the U.S. Supreme Court could hear arguments in any of 8 qualified immunity cases in front of them right now.
But this seems like it is a pressing issue that the court may well take up.
Now, the police accountability bill in its current form does have a little bit of leniency for officers. Farrell says something called a reasonability defense. Basically, if they had a reasonable belief that their conduct was legal, well, then their department would be liable for the legal bills. But if they do not have that reasonability standard, they could be liable personally for up to 5% of the judgment, up to $25,000, whichever one of those numbers is less. Kyle.
See, I think there are a number of professions out there where folks have some personal liability if they do wrong on the job. And a lot of those other professions, people carry insurance for that.
So insurance is actually written into this bill. It said if the peace officer cannot pay for this, that their insurance would be held liable for it. I did some calling around today to experts on insurance, and they tell me there's really no policy that exists right now. Obviously, this is a new law, so if it does eventually pass, maybe they will make a policy, but they said there's no policy that exists right now. And the folks who crafted the bill, a representative from the ACLU told me the thought may be that that could be a union responsibility. Maybe the union would provide some sort of insurance to officers that they could use for this personal liability. It's a lot of it is still up in the air, but that's a big question.
All right. Steve Steger, thank you very much.